All hell broke loose. We actually had a breach a week prior, and we had pretty good monitoring on our networks. We knew that somebody was in our network straight away, and we went into a lockdown mode, and we actually reconfigured our network during that week, but there were mistakes made during that process that enabled the re-entry a week later. The second week when we knew we'd been hacked was when they changed our homepage on our website, and they put a fairly nasty message on there, and then my phone started beeping with all my alerts of all the servers going offline one after the other. And I was scrolling through my external alerts on my phone, every one of them was red. And that happened within about 3 or 4 minutes, the whole lot went down. So if you've got appropriate monitoring, you'll know pretty quickly that something's going wrong.
There are changes happening in March. Those people who follow privacy for whatever reason, aren't paid to do so like I am, may recall that in 2008, quite a long time ago now, the Australian Law Reform Commission undertook its biggest reference ever, and for about a year or 18 months was doing a review of privacy law in Australia, produced an enormous report of 3 volumes and 290 something recommendations to reform the law of privacy in Australia. That's been slowly being implemented, partially implemented at least by the federal government. The most notable implementation is this latest reform. Basically what it's designed to do is, at the moment in the Federal Privacy Act, there's 2 sets of principles. The information privacy principles, which apply to the Commonwealth agencies, and they were the first set of principles from the 1980s. So Centrelink, the Tax Office, those sorts of organisations. And there's a second set of principles in that Act, the national privacy principles, that apply to private sector organisations that have a turnover of more than $3 million a year. So that what they're trying to do is have one set of principles that apply to Commonwealth agencies and the private sector. Our office has been pretty critical of those principles. The idea from the ALRC was that they'd be made simple and transparent and lucid and all those sorts of nice words. In our view, the opposite has happened. We think the NPPs that apply to the private sector already were pretty straightforward and easy to comply with, or relatively. And they're the same principles that apply to Victorian government agencies that we regulate, because at the time, 2001, when they were legislated, was when the state legislation was happening here. Unfortunately, in the drafting process, trying to amalgamate those two, the new principles are actually quite complicated. And in some instances, it still says, if you're an agency, this will apply. If you're an organisation, this will apply. So they're not actually, in some instances, one set of principles anyway. They're co-located in the Act now, but still different rules apply to the Commonwealth agencies than apply to the private sector. So it's really the complexity of them that is our major concern. And in some instances, they've actually lowered the privacy protection. So that's also, given that the bill to introduce them was called I can't exactly remember the words, but it was about improving privacy, and they've done the opposite in some instances. So the major changes are that the transporter data rules are quite different. So that if you send information outside of Australia, and to an extent all businesses do that because of what we were just talking about, the cloud, there's an obligation now that you do that either with consent, and where you know where you're going to send the information, you're meant to tell your customer that. So that they can consent knowing where it's going to go. Again, with the cloud, that's difficult. And we've got a problem with it being with consent, because in a sense, what are people consenting to and how do you do that? If you can't do it with consent, then you've got to take all reasonable steps to make sure it's still going to be protected as if it were in Australia. And if it's not, and if something goes horribly wrong, you're then responsible as though it was you that did the breach. So that will then mean that, if you send it off to a provider in Tennessee or somewhere and something goes wrong, because the Australians can't recover against that person in Tennessee, they'll come against you. So that's one of the major changes. There are some other changes, but they're more really conceptual, and it's really the complexity that we have a problem with.
Our SurveyMonkey is based in Canada, and many people use SurveyMonkey. So if you have to tell everybody in the survey, hey, it's based in Canada, and they go, but they threw me out 10 years ago, I can't do that. Where does that leave everyone?
That's right. One of the other changes with the cross-border, at the moment, the company simply has to satisfy itself that there's a similar set of laws applying in the jurisdiction they're sending it to. The change now is that not only does it need to be similar legal protection, but an Australian would need to be able to recover under that jurisdiction, and that's almost not true anywhere. So that even if you're sending it to Europe, where there are quite stringent rules, somebody from Melbourne's not going to be able to make a complaint to the German Privacy Commissioner and participate in conciliation and do all those things. So it basically means that you'll be responsible if something goes wrong if you send it outside the jurisdiction, unless you somehow manage to make an argument that the person's consented. And that's the concern we have, that if the idea is that Australians be able to have some kind of remedy where their information's been sent somewhere else, if that consent mechanism is too loosely interpreted and just ticking a box and impliedly consenting, it may mean that that principle doesn't have any force at all, and so it may not actually improve privacy protection, it might do the opposite. And that's certainly what the privacy advocates have been saying. They have a real concern about that because the consent is slightly vague, that principle as to what it's going to mean.
Two things popped into my mind there. Does these privacy regulations apply to all business? Is there like a scale, or because I can imagine people listening now are panicking that if they're sharing their data, they're going to be responsible for this. So who comes under the Privacy Act?
Yeah, well, basically the Act I administer, the Victorian one, it's Victorian public sector organisations, so places like this university, government departments, local councils, and private sector organisations that contract with any of those. So we have some jurisdiction over the private sector if you contract with the Victorian public sector. The Federal Act applies, as I've said, to Commonwealth agencies and then to private sector organisations, but only if you have an annual turnover of more than $3 million. So small business, the idea is kind of left out. Now there are exceptions to the exceptions, basically, so that if you deal in personal information, so if you're a direct marketer or you're a data broker, those sorts of businesses where your whole business is personal information, then it doesn't matter what your turnover is, you'll be covered by it anyway. And there are other exemptions like political parties aren't covered. Employee records, quite extraordinarily, usually when I tell people that, they're shocked and horrified if they were work for the private sector to learn that anything that's in their employee record isn't covered by privacy legislation, which seems a bizarre exception to me. Apart from your doctor and your life partner, probably your employer knows more about you than anyone, and yet there's no, under HR laws, there might be a reason for them to protect it, but not under privacy law. Journalism and news gathering is an exemption for which you can see the reason for that. So that's basically how it works. So if you're a very small business with a less than $3 million turnover and you don't deal primarily in personal information, then you're not covered by the laws. But that wouldn't be, I still think that's not a reason to completely relax, because in the US, which doesn't have comprehensive private sector privacy laws, the way that businesses have been got at there really is that their Federal Trade Commission has basically used their consumer protection laws to go after organisations who say one thing and then don't live up to it. So if they have a privacy policy which says we'll do all these sorts of things and then they don't, they basically seen that as being misleading conduct, and so they've taken action against all sorts of size organisations there, and that's a possibility here. The law is basically similar, so the ACCC could get into their head to do that as well. And I think also there'd be an argument that if you take no steps to protect your customers' information and they suffer really egregious damage from it, they probably wouldn't need to rely on privacy legislation. They'd probably just sue you for negligence about not having done your due diligence and taken reasonable care of their information. So certainly I think the responsibilities are different, and under the privacy legislation you have to take reasonable steps. So what reasonable steps are, if you're Australia Post for instance, will be different than if you're a very small organisation with hardly any staff, and that's why it's expressed like that, so it's a sliding scale. But I certainly think, I don't think anybody should think they don't have any responsibility at all. So.
Do you have any sense as to whether the Australian privacy principles are going to be adopted by each of the states? I know the ALRC report had suggested that as a possibility, and I hear you saying your office is not particularly happy with them.
Yeah. Basically, we've been looking at that because what part of our expansion of responsibility really is that our legislation is going to be repealed and replaced with a new act. So one of the things that the government is looking at is whether to have a new set of principles. At the moment, they're minded not to adopt the APPs partly for the reasons I've just said. We don't think they're very good. In terms of the other jurisdictions, I don't think New South Wales are looking at all changing their privacy legislation, so they won't be. Queensland's doing their kind of 5-yearly review of their privacy legislation, but it started in 2011. I think the committee in charge is yet to meet. So there's probably not a big impetus there either. I think the Queensland government might actually like to repeal their privacy legislation if they're going to do anything and not replace it with anything. But South Australia and Western Australia don't have privacy legislation at this point. South Australia is actually, they've had fits and starts of actually, I've been to meetings since 1998 when I was first involved in this area, where South Australia periodically announces that they're drafting legislation and then comes to nothing. But they're at one of those stages again, and it does seem to have some political will now. And they are looking at whether or not they might use the Australian privacy principles as a model. Our thinking prior to that had been they'd do what Queensland did, and Queensland had an administrative scheme that their public sector was meant to comply with before there was legislation, and they simply made that into legislation, so that was what they were used to. And South Australia, I think, is tossing up whether they do that or they adopt the federal model. Western Australia is quite stridently not doing anything, so it's unlikely in the near future we'll see Western Australian privacy legislation. Tasmania and Northern Territory, the ACT, already have a scheme. The ACT complies with the Federal Act, and the Northern Territory and Tasmania, I haven't heard that they're looking at doing anything in particular. So it's still going to be a mismatch. Partly the process by which the Commonwealth went through was simply to focus on their own act, and they didn't get the states involved up to this stage. So there'll be a long, protracted COAG or Standing Committee of Law and Justice Ministers process, one imagines, to really have national harmony. And so I don't see that happening anytime soon.
This question's to the panel. We started off at the start. There was a comment made about the cost of security. So my hat is coming from the business guy. All right. So I'm a developer. I want to put a system out there. Is the cost of accreditation, standards, security going to stifle competitiveness in Australia? Well, I mean, why can't I just go and put a server out in Asia?
Troy.
I'm happy to answer that one. So, short answer is yes, it can at times. However, that doesn't detract the need to do it. I think, as we talk through privacy legislation, things like ISO 27001 and the other standards, PCI, they have great standards to follow, and they give you some really good kind of guidelines and directions to head in. Having said that, they don't cover everything. They don't need everything that you need. And so, I think, again, talking about transborder and cloud, yes, you're outsourcing technology, but you're not outsourcing governance or responsibility, and so you've always got that responsibility as an organisation. As I said, my role is about enabling and protecting, so I am absolutely looking for every possible opportunity that I can to enable our developers, our testing teams, to use cheaper services that also maintain a level of security. Just because we're using a cloud provider offshore doesn't mean that I'm getting less security. In some cases, I'm actually getting better security than by keeping it in Australia. Certain application sets, I would much rather trust a global organisation that's invested billions of dollars in R&D and has great security than a small startup in Australia, because that's the only option. And so I think it's just responded on us to find the right solutions, the right cost, the right everything that matches kind of what the business needs to do.
When you say responded on us, you mean Australia Post, right? So
on each individual organisation. So so that's my day job is that. Yeah. My night job is my wife and I run a small business ourselves. So a business of one. The wife. It's an
You're
online
a consultant, right?
I'm the warehouse manager. It's an online wine business, right? And so as an organisation of one, we are still customer data, taking financial transactions. It is still respondent on us as that entity to keep our customers secure and our data secure. And so to the point, different levels. Certainly my security budget at Australia Post is different than my security budget.
I was just going to say that.
Right? But it's still exactly the same requirements, and so I still need to make sure both businesses are secure.
Thank you.
Can I say one little thing?
Yes, please.
And again, direct experience and with the recent legislation going to Parliament for mandatory data breach reporting, what I can say is the cost of protecting an organisation is relative to its size. But the cost of protecting an organisation is less than the cost of the proposed fines, and that in turn is far less than the economic cost that you will suffer if you don't do it. So I would suggest that rather than, and I think, and 3 years ago, same boat. We're in a highly competitive market where the margins on a domain name registration have reduced from $40 over 2 years to $1.
Yeah.
Hosting providers would reduce their pricing from $20 a month for a basic website down to $2 a month. That investing in some of these things was just impossible, in our opinion. It was very, very difficult, and it would have potentially made us uncompetitive, or it would have just potentially made us unprofitable. So it's certainly a difficult decision, but if you're going with the mindset that I have to take protective measures, and obviously relative to my business, and knowing that there's now some fines that might be thrown at you, and but the bigger picture is that there's obviously a much bigger loss that's at stake.
There are useful things in something like the PCI compliance standards, which allow you to almost test the person you're consulting with or the company that you're using to check that things are done according to a certain process. And it goes back to other questions. One that was asked earlier: how do you know that you've been hacked? Well, generally, you know, because the hacker has made some kind of a public message on your website, as an example. But in some cases, there may be no traces at all, and that then goes down to your monitoring systems. So how do you know that the IT consultant that you're using has put in place a monitoring system that will actually catch these? In a lot of cases, it's difficult to know that. But there are guidelines within some of those processes, some of those ISO standards that we mentioned earlier, and some of the PCI compliance ones that help you as a business owner have some level of checks and balances against what your provider is performing.
So is that a certificate or something? Can you ask your IT consultant to say, show me your PCI compliance?
PCI compliance is a set of processes that are more for the business themselves. So the IT provider, I'm not aware, would be providing services in a PCI compliant fashion. But these sorts of questions straight away will help separate the reputable companies from the ones that don't. If you're dealing with an IT provider that says to you, I have no idea what PCI compliance is, that's probably not a good sign. But one that has that level of understanding around legal obligations and around privacy, around data protection, these are some of the things that you as a business owner can use to test that knowledge.
Troy?
So for the startup business that doesn't have a strong background in technology or security, I'd ask two questions. The first would be, can you show me your privacy policy? An organisation that's got one has actually spent some time thinking about it. One that doesn't, I'd run away from. And then the second question I'd ask would be, how are you securing data? And I can guarantee in 98% of the good cases, they will have a one-page PDF or a two-page document or something that they will send to you. I don't know, if you get those two things, you've kind of got a level of assurance. Then from that, if there's any red flags, go and talk to someone. There's plenty of organisations out there that will provide kind of consulting services, but more specifically, just some general practical advice on who's good and who's not.